right. Thank you. Plea, how are you? Thank you. Mhm. Who you want to start with, Pam? Hang on, we're missing the Kerr County Jail, I think. Yeah, I don't have the Kerr County Jail on here.
I just wrote wherever his name was, it was Jacob Toby Martinez or previously known as Jacob. But it's in the indictment, so I think on all three indictments.
We have to amend
he's
it.
gonna have to file them in the one.
Okay.
There's the, I guess I'm on my side.
Yeah. Marcus, that's one.
There's three cases.
Doesn't matter if we can't get to jail.
Oh,
We have the Bandera County Jail. Can we do anything?
yeah, that's just, I thought. No, I just didn't know what to do.
There's the Kerr County Jail.
Because I got a big white smile. Oh, this is- You gave her?
All right, if you can hear me in the Kerr County Jail,
Yes, sir.
we're actually going to start out with Mr. Jacob Rodriguez, please.
Yes, sir. Let me get him for you.
Thank you. Do we have paperwork? Can I have the paperwork?
They tell you what he said when you're done. Yeah,
Hmm.
you got there. Oh, Lord.
A little overly enthusiastic, was it?
I mean, look at the picture from Orange. So he lives here, right? Yeah.
Yeah, I think he lives in Barney, if I'm not
Oh,
mistaken.
yeah. Don't you really go at the TV on the 40-hour lawyer stuff? Basic.
I want to come around behind me so you can actually see him. Yeah, pretty much. Good morning. Court will call cause number B 2129, 21-555, and 556, State of Texas versus Jacob Rodriguez. For purposes of an agreed plea, what say the parties?
State's ready, Your Honor.
Defendant's ready, Your Honor.
And Your Honor, just by way of housekeeping, it was brought to our attention that the defendant's name is actually Jacob Toby Martinez. So the state would request a trial amendment to correct all the documents and the indictments to correctly reflect the defendant's actual name, Jacob Toby Martinez, and I believe there's an exhibit.
Yeah, Judge, as I said, we initially tendered a fairly new copy of my client's birth certificate that his mother provided to me, where it correctly reflects that his name at a very young age was changed legally to Jacob Toby Martinez. And we don't have any objection. That is part of the plea agreement. We don't have any objection to trial amendment as reflected therein. And I've reviewed this thoroughly with Mr. Martinez.
Mr. Martinez?
Yes, sir.
Okay, would it be correct that your correct legal name is Jacob Toby Martinez?
Yes, sir.
All right, the court, let's pause for just a minute and we're going to make an amendment to the indictment. Do this, change it on all three, and let's get everybody's initials on all three.
What do you want to do?
Okay, we're going to have to change them.
Okay. What's the other thing? I can finish with this permission.
As long as you do. Okay. Name's got to be changed all the way through here.
I am, well, I did make where he had to sign and stuff. I did make it.
I'm going to go ahead and go through the pleas on all three of these. And then we're going to sit down and change all the stuff. Court will note for purposes of the record that the indictment amendment has been made, that the court is in possession of a copy of the birth certificate indicating that the defendant's true name is Jacob Toby Martinez. For purposes of an agreed plea on all three cases, what say the parties?
State's ready.
Defendant is ready, Your Honor.
First document we need to go through on all three cases is the 3914 Discovery, Disclosure, and Compliance Form, counsel, which includes both your signatures on each of the documents. Is that correct?
That's correct, Your Honor.
It is, Your Honor.
To the best of your knowledge, has the state received all discovery from law enforcement on all three cases and reported the same to the defense?
Yes, Your Honor.
To the best of your knowledge, have you received all discovery on all three cases?
We have, Your Honor.
Next document we need to go through is a joint request for plea or sentencing by video conference on all three cases. It purports to have your signature, Mr. Martinez. Is that correct?
Yes, sir.
And do you have any objection to proceeding by video conference today on these three cases?
No, sir.
Thank you. Next document we need to go through in all three cases is defendant's plea of guilty, waivers, and admonishments. Mr. Martinez, I'm showing you this document. There's one of these in each of the three cases. Is there any objection to going through the admonishments together?
No objection.
Did you have a chance to go through all three of those documents with your attorney?
Yes, sir.
Did you understand all three of those documents?
Yes, sir.
Do you understand in each case you have a right to a trial by jury?
Yes, sir.
In each case, you have the right for your attorney to cross-examine the state's witnesses and to call your own witnesses.
Yes, sir.
And do you understand in each case you have the right to appeal?
Yes, sir.
Do you understand that you're waiving all three of those rights in all three cases today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
Page 3 of each of these documents purports to have your signature in two different locations. Is that your signature in two spots on page 3 of each of the documents?
Yes, sir.
Your second signature on each one appears underneath a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing that paragraph in all three cases, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing in all three cases.
Yes, sir.
Attached to the back of each of these three documents is a copy of the grand jury indictment. Each of the three purports to have your signature at the bottom. Do you recall signing all three grand jury indictments?
Yes, sir.
And are you asking the court to accept as true and correct all three grand jury indictments?
Yes, sir.
Do you feel like your client understands his rights, waivers, and admonishments in all three cases?
He does, Judge. By way of information, we signed the paperwork back on September 2nd, and then the case was reset. And via Zoom conference on Wednesday, I went over all of the paperwork again with Mr. Martinez, and he confirmed his willingness and desire to enter the plea, and the paperwork is executed.
Thank you. Signature on there.
Yeah.
You want to tell them what's going to
Mr. Martinez, Mr. Stedman's going to bring one document back out to you. It's in cause number B21555, and it's your appeal notification. And we need to get your signature on there. Somehow it was missed, okay?
Okay.
The next document we need to go through in all three cases is the agreed stipulation of evidence and waiver of testing. Did you go through all three of those documents with your attorney?
Yes, sir.
Did you understand all three of those documents?
Yes, sir.
And do you recall signing all three of those documents?
Yes, sir.
And do you understand that by signing those documents, you're stipulating that the evidence is what the state says it is, and you're waiving your right to have it tested?
Yes, sir.
In B2129 and B21556, each of those cases you've been charged with possession with intent to deliver a controlled substance in penalty group 2, to wit THC from 1 to 4 grams. Each one of those is a second-degree felony with a range of punishment of 2 to 20 years incarceration and up to a $10,000 fine. Do you understand that charge and that range of punishment in both cases?
Yes, sir.
In B2129, how do you plead?
Guilty.
In B21556, how do you plead?
Guilty.
In cause number B21555, you've been charged with possession with intent to deliver a controlled substance, to wit THC from 4 to 400 grams. This is a first-degree felony with a range of punishment of 5 to 99 years of life and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
How do you plead?
Guilty.
In all three of those cases, are you pleading guilty freely and voluntarily?
Yes, sir.
In all three of those cases, are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir.
Do you feel like your client's competent and capable of assisting you in preparation for trial in all three cases?
I do, Your Honor.
Are there plea agreements in all three cases?
Yes, Your Honor. In case number B2129, 4 years deferred adjudication probation, $2,000 fine, drug and alcohol treatment approved by the probation department and completion of the LTIP class. And then in 21-555 and 556, 4 years deferred adjudication probation, drug or alcohol treatment approved by the probation department, LTIP course, and then also the defendant agrees to forfeit ownership of $1,289 in lieu of the state's right to seize. And those cases run concurrently, Your Honor.
Mr. Stedman?
That is correct, Your Honor. In B1, 2129, my client also agreed to enter into an agreed default on the seizure action for approximately, I believe it was $3,000, that we are forfeiting his right to pursue and defend at this point.
That's correct, Your Honor.
Mr. Martinez, is that your understanding of all three plea agreements?
Yes, sir.
Let's talk about deferred adjudication. Deferred adjudication is like a two-sided coin. If you successfully complete all your terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure. Do you understand that?
Yes, sir.
Okay, do you understand the flip side of the coin? If you violate your terms and conditions of probation, you're subject to the full range of punishment for all three of these offenses, which on one of them being a first-degree felony, you understand is up to 99 years of life.
Yes, sir.
In addition to that, you understand that a plea agreement's an agreement between you and the state. It's not binding on the court, but if the court did not accept any one of your plea agreements, you would have the opportunity to withdraw your pleas of guilty, enter pleas of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow all three plea agreements?
Yes, sir.
B2129, B21555, and 556, in all three cases, the court will find evidence beyond a reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, will defer any such finding of guilt for a period of 4 years. In cause number 2129, you have a $2,000 fine. You must successfully complete a drug or alcohol treatment program if ordered to do so by probation. You must successfully complete the Life Training Institute program. You have court cost in the amount of $375. In B21555, you must successfully complete the drug or alcohol treatment program if ordered to do so by probation. You must successfully complete the Life Training Institute program. You're agreeing to forfeit ownership of $1,289 in lieu of the state's right of seizure. And you have court cost in the amount of $365. In B21556, you must successfully complete the drug and alcohol treatment program as approved by the probation department. You must successfully complete the Life Training Institute program. Is this the same seizure on both of these?
It is, Your Honor. There's only one.
Okay.
seizure. They were a combination.
Okay. You're also agreeing in this case to forfeit the $1,289 in seizure, and you have court cost in the amount of $365. In addition to that, on B2129, there's an agreed forfeiture of seizure for $3,000.
It's 3,000. Yeah, but I believe you already submitted. That document was already submitted to the other paper. I'll check my paperwork. but I believe-
Okay. There's an agreed forfeiture of seizure of a little over $3,000. Do you have any questions on any of those three judgments?
No, sir.
Attached to the back of each of these three judgments is an order granting community supervision. Did you have a chance to go through all three of those orders with your attorney?
Yes, sir.
Did you understand all three of those orders?
Yes, sir.
Do you understand those orders contain all your terms and conditions of probation?
Yes, sir.
Do you understand that as a term and condition of probation, you have a $60 per month probation fee?
Yes, sir.
There's three cases, but there's only going to be one fee, okay?
Okay. Yes, sir.
Each of the three cases will have a one-time $50 Crime Stoppers fee that's due within 6 months. Do you understand that?
Yes, sir.
You understand you're subject to random urinalysis and drug test at your own expense.
Yes, sir.
You understand that you're agreeing to search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation.
Yes, sir.
You understand you must successfully complete the Life Training Institute program.
Yes, sir.
You understand that if ordered by probation, you must successfully complete a drug and alcohol treatment program.
Yes, sir.
Where do you work?
I currently don't work at the moment.
What do you normally do?
I was working at a liquor store here in Kerrville.
Yeah, that's going to be a little bit of a problem because of your probation conditions.
Yeah.
We're requesting that his probation be canceled. His mother's here today. He's gonna move in with her. He lives in Bender.
I'm going to put all your community service in one case. It's going to be in B21-555, and you have 300 hours of community service you need to knock out, okay?
Okay.
Do you have any questions at all on any of these three terms and conditions of probation?
No, sir.
All right. Good luck to you, Mr. Martinez. Thank you.
Thank you.
Judge, do we know who's next?
Give me just a minute and I can tell you. Well, that's what we usually do, but. Yeah. I'm going to give these to you, but all three of them get changed before you copy. Last name's got to be changed on all three cases, on like every document. Yeah. Sure. Okay, let's do Alex Carlos next.
Yes, sir.
Your Honor, while we wait, on Crockett Lara, Ben and I agreed to reset that to November 5th. I sent over an agreed order to Christine yesterday at some point.
That's what I'm showing. I'm showing it's reset.
Okay. Well, that's all I had. May I be excused?
You bet. Have a good weekend.
Yes, sir. You too.
Thank you. Sorry. It's in that stack of paperwork. Everything else was signed.
Do you need me one?
I don't think so, unless you want to just look over their shoulder while they change the name on everything. Ask Stephen for purposes of TDC in case it gets revoked. If it's better to white it out and change it or strike through it and write above it.
Budget.
Bye.
Judge, give us just a sec.
Thank you.
And did I hear that Mr. Lara was reset?
Correct. And it looks like Gary LaSalle was also reset.
Okay.
So we have Carlos coming out.
Yes, sir. He's on his way up.
Okay, and then we'll do Grantham and then Smith.
Okay, great.
The very last one, Alex Carlos.
You on mute?
Okay, here we go. How are you, Mr. Stevens?
I'm good, thanks, Judge. How are you?
Peachy, thank you. Court will call cause number B21-304 and 305, the state of Texas versus Alex Carlos. For purposes of show cause, what say the parties?
I think ready.
Defense is ready too, Judge.
Rosenbach?
Your Honor, it came to our attention, through the defendant, that there is some monies that he wishes to withdraw and put on his accounts. And as a part of the plea deal to the cases that he pled to, there is a restitution payment due to the victims in the cases. And so we think that if he were to try to withdraw that, he needs to make the payment to the restitution and not have it for his property account in wherever he is headed off to as part of his plea bargain. So he wanted to be heard on that. That was our stance on it. And so that's why we're here today.
Thank you, Mr. Stevens.
Yes, Judge, that's right. Mr. Carlos pled a couple of weeks ago to 5 years TDC. concurrent with a 2-year state jail sentence. He's headed off to TDC. He's getting ready to catch chain, actually. He has $700, I believe, or somewhere thereabouts in cash. That's either part of evidence or part of his property that he is wanting, as Mr. Rosenbach said. He does have a restitution payment of about $3,000, as I recall, and total costs and fees totaling about $4,200. But he's requesting that $700 be returned to him so that he can have it on his books or use it in whatever manner. Obviously, understanding that the county does have an ability to withdraw whatever, some part of whatever's on his books while he's at TDC.
It was collected during the arrest.
It was collected during the arrest.
Found in the left side of the refrigerator, against the back wall behind the refrigerator, $728.
And there is or there is not a direct tie between that money and the two cases he was convicted on.
There is, Your Honor, because he essentially broke into these people's house and then he, for one reason or another, he put supposedly this cash behind a refrigerator and he was bleeding and it was a whole, just a total chaotic thing. But he had put, the owners of the property that he broke into and were like, well, that's definitely not our cash. And so it was taken, he claimed ownership of it. But during the course of this criminal episode, he destroyed a lot of things in this people's place. And that was why the restitution payment was so high.
Judge, to jump in there for a second, I would just say that Mr. Rosenbach is right, but just because he was arrested with money doesn't necessarily make it, in my opinion. I mean, there's no allegation of him stealing that money from the habitation that he pled guilty to. He is, by law, there's no dispute that he owes the restitution that he owes. There's no dispute that he has to pay the fees and costs that total about $4,200. And the county does have the ability to withdraw whatever a percentage of whatever remains on his books. I suppose the request here is for the $700 to be put back to his personal use. There sort of is effectively a lien on that money regardless, so that he can have it while he's spending his 5 years locked up.
And this money was not addressed anywhere in the adjudication of the cases?
No, Your Honor.
And I think the county's limited. The county can withdraw 25%, and then the rest of it belongs to Mr. Carlos. And it'll transfer with him to TDCJ.
Okay, Your Honor.
Now, Mr. Carlos, you understand that the county has a right each month to make a withdrawal from your account. It's not that much. It's a much smaller amount, but
It's just that all this money that I had gotten, is for my stimulus check. And when I was being chased, these people was trying to kill me. That's the only reason why I went to this house to get help. The county doesn't believe me, but it's my testimony to say, that's it. But that money ain't stolen. That money that could be traced, there's $200 bills and $10, $50 bills. It could be traced to the Security State Bank from Comfort from March 20th through the 25th, one of those days that I cashed it in. But I understand that they could withdraw, but I don't have a family. I don't have nobody. I do got a big family here in Comfort, but they're all. I don't associate with my family because of how they grew up and how they are. I don't have nobody. I did 10 years by myself. Back in 2000 and stuff, but.
well, the county pursuant to the withdrawal rules has a right to pull 25% out of the initial deposit for the restitution. So that's what'll happen, and the rest of it is going to follow you to TDCJ. Okay.
When will it be released? I mean, today or?
I'm not sure I understand your question.
The money, will you have it released today or, something?
I won't swear to the court order will come through today. It'll depend on when the court order is prepared. Okay.
Yes, sir.
All right. Thank you, Mr. Carlos. Thanks, Mr. Stevens.
Thank you.
Thank you, Judge. That's all I have. May I be excused?
Hey, thank you.
Thank you.
Can we do
We're doing-
Curtis Grantham, or is
Yeah.
that?
Yeah, we're doing Grantham and then we're doing Smith.
Okay, this.
Try this again. Mr. Grantham, how are you?
Good, how are you?
Good, thank you. Court will call cause number B20-277, the state of Texas versus Curtis Grantham. For purposes of an agreed plea, what say the parties?
Defense is ready.
First document we need to go through is the joint request for plea or sentencing by video conference. It purports to have the signature of all the parties. Mr. Grantham, do you have any objection to proceeding today by video conference?
No, sir.
Thank you. Next document we need to go through is the 3914 Discovery Disclosure and Compliance Form, which purports to have each of your signatures. Is that correct?
Yes, sir.
Yes, Your Honor.
To the best of your knowledge, has the state received all discovery from law enforcement and forwarded the same to the defense?
Yes, Your Honor.
To the best of your knowledge, have you received all the discovery?
Yes.
Well, shoot, hang on. Mr. Grantham, I'm showing you a document entitled Defendant's Plea of Guilty, Waivers, and Admonishments. Did you have a chance to go through this document with your attorney?
Yes, sir.
Did you understand this document?
Yes, sir.
Do you understand that you have a right to a trial by jury?
Yes, sir.
Do you understand that you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And do you understand you have a right to appeal?
Yes, sir.
Do you understand that you're waiving all three of those rights today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody can require you to testify against yourself, but you can in fact waive that right.
Yes, sir.
Page 3 of this document purports to have your signature in two different locations. That's your signature in both spots?
Yes.
Your second signature appears below a paragraph entitled Judicial Confessions and Stipulations. Do you understand that by signing this paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing?
Yes, sir.
Attached to the back of this document is a copy of the grand jury indictment. And on page 2, it purports to have your signature. Is that your signature?
Yes, sir.
And are you asking the court to accept as true and correct this grand jury indictment, including the prior enhancement?
Yes, sir.
Do you feel like your client understands his rights, waivers, and admonishments?
I do, Your Honor.
Mr. Grantham, in both count 1 and count 2, you've been charged with assault, family violence on a household member enhanced. As enhanced, each of these is a second-degree felony with a range of punishment of 2 to 20 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you plead to count 1?
Guilty.
How do you plead to count 2?
Guilty.
On each of these, are you pleading guilty freely and voluntarily?
Yes, sir.
On each of these, are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
And are you a citizen of the United States?
Yes, sir.
Do you feel like your client's competent and capable of assisting you in preparation for trial in these cases?
I do, Your Honor.
Are there plea agreements in both cases?
There are, Your Honor. And 2277, count 1, 10 years deferred adjudication, probation, no early termination of probation, 0 tolerance on any probation violations, $5,000 fine, drug and alcohol treatment, to prove by the probation department, no contact with the victim, big class and the LTIP class, and it's the same terms on count 2, except there is no fine.
Is that your understanding, Mr. Runkin?
It is.
Mr. Grantham, is that your understanding of both counts, plea agreements?
Yes, sir.
Let's talk about deferred adjudication. You understand that deferred adjudication is like a two-sided coin. If you successfully complete all your terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure.
Yes, sir.
And you understand the flip side of the coin. If you violate your terms and conditions of probation, you're subject to the full range of punishment on each of these counts, which is up to 20 years incarceration.
Yes, sir.
In addition to that, do you understand that a plea agreement is an agreement between you and the state? It's not binding on the court, but if the court did not accept either one of your plea agreements, you would have the opportunity to withdraw your pleas of guilty, enter pleas of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow both plea agreements?
Yes, sir.
B-2277, count 1 and count 2. Court will find evidence beyond a reasonable doubt to enter a finding of guilt. In addition to that, we'll enter a finding of true to the enhancement. On each of these cases, we'll defer any such finding of guilt for a period of 10 years. There's no early termination of probation. There's going to be there's 0 tolerance of any probation violation. In count 1, you have a $5,000 fine. In both cases, if ordered by probation, you must successfully complete a drug and alcohol treatment program. In both cases, you're not allowed to have any contact of any kind with the victim. You must successfully complete the Batterers Intervention and Prevention Program and the Life Training Institute program. In count 1, you have court costing the amount of $290, and you have reimbursement fees totaling $2,053. Do you have any questions on either one of these judgments?
No, sir.
Once you get released, can you work out a payment plan to pay off your cost?
Easily. Yes, sir.
Attached to the back of each of these judgments is an order granting community supervision. Did you have a chance to go through both of those orders with your attorney?
Yes, sir.
Did you understand both of those orders?
Yes, sir.
Do you understand those orders contain all your terms and conditions of probation?
Yes, sir.
You understand your terms and conditions of probation include a $60 per month probation fee?
Yes, sir.
2 cases, but there's only 1 fee, okay?
Yes, sir. Thank you.
Each of the cases carries a one-time $50 Crime Stoppers fee that's due within 6 months.
Okay. Yes, sir.
You understand you're subject to random urinalysis and drug tests at your own expense.
Yes, sir.
You understand you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation.
Yes, sir.
You understand you must successfully complete the Batter's Intervention and Prevention Program.
Yes, sir.
You understand you must successfully complete the Life Training Institute program.
Yes, sir.
And do you understand that if ordered by probation, you must successfully complete a drug and alcohol treatment program?
Yes, sir.
You understand that you absolutely cannot have any contact of any kind with either victim.
Yes, sir.
And do you understand that there's going to be strict enforcement of the probation terms and conditions?
Yes, sir.
Where do you work?
I work for Infinity Drywall.
I'm sorry, for whom?
Infinity?
All your community service is going to be in count 1. You have 300 hours of community service you need to knock out. So work with your probation department so they can work around your job. Okay.
Yes, sir.
You have any questions?
No, sir.
Any questions at all about either case?
No, sir.
All right. Good luck to you, Mr. Grantham.
Thank you, sir.
Thank you. Smith is a show cause.
Yes, sir. He came before the visiting judge. The visiting judge felt like it was a conflict. Whether he needs to go to CCP. He can't go to CCP without.
Grantham? Oh, he's wasted. Yeah. How are you, Mr. Smith?
Good, how are you, sir?
Good, thank you. Court will call cause number B20-377, State of Texas versus Charles Smith. For purposes of a show cause hearing, what say the parties?
I'm present, Your Honor.
And Mr. Smith, do you have a defense attorney today?
Good morning, Your Honor. Gary Hillier present for Mr. Smith, and we're ready to proceed.
Thank you. Ms. Koenig?
Just to give you a brief rundown, the original show cause hearing was last week. We had discussed the fact that Mr. Smith was on insulin, and at CCF, they will not take someone on injection insulin or on a pump. It is my understanding since then, as of 3 days ago, Mr. Smith is now on a pill called glipizide for his insulin. I spoke with CCF. As long as Mr. Smith can have his pills sent to, he has the opportunity to either get the pills at CCF or have a support system that can give him the pills and mail them to him for a 60-day period while he's in CCF, then he has the ability to go there. They just did not want him there if he was on insulin injections or an insulin pump. That's my understanding now. He is taking pills, and he would be able to go to CCF now.
Mr. Smith, are you taking pills or are you still on the shots?
I'm taking pills, sir.
And do those seem to be working appropriately?
Yes, sir.
So the situation somewhat resolved itself?
Yes, sir.
All right. You have any questions at all?
No, sir.
We'll see you when you get back from CCF. Thank you.
Thank you, sir.
Good luck, Charles.
Thank you.
Thank
See
you,
you
Your
later.
Honor.
Thank you, ma'am.
Thanks.
May we excuse, Your Honor?
You may. Thank you.
Thank you, Judge. Have a good day.
Thank you. You too. So we through with the Kerr County Jail? All right, who do you want to do first out of Bandera?
I don't see Umberto on mine, so we can do that.
Okay. If you can hear me in the Bandera County Jail, let's do Laura's story first.
Morning, Judge.
Good morning, David. How are you?
Fine, thanks. How are you doing?
Peachy.
Good.
Friday. Life is good.
Yeah, it is.
Hello.
How are you?
Good.
Good. Give me just a second to get organized here. Court will call cause number CR 19-196, State of Texas versus Laura Story. For purposes of an agreed plea, what say the parties?
State's ready. Defense is ready.
First document we need to go through, counsel, is the joint request for plea or sentencing by video conference. It purports to have each party's signature. Ms. Story, do you have any objection to proceeding by video conference?
No, sir.
Thank you. The next document we need to go through is the 3914 Discovery Disclosure and Compliance Form, which purports to have each of your signatures on it, counsel. Is that correct?
Yes, Your Honor. Yes, sir.
To the best of your knowledge, has the state received all discovery from law enforcement and forwarded the same to the defense?
Yes, sir.
To the best of your knowledge, have you received all the discovery?
Yes, sir.
This story, I'm showing you a document entitled Defendant's Plea of Guilty, Waivers, and Admonishments. Did you have a chance to go through that document with your attorney?
Yes, sir.
Did you understand that document?
Yes.
Do you understand that you have a right to a trial by jury?
Yes.
Do you understand you have a right for your attorney to cross-examine the state's witnesses and to call your own witnesses?
Yes, sir.
And do you understand you have a right to appeal?
Yes.
Do you understand that you're waiving all three of those rights today?
Yes, sir.
In addition to that, do you understand that you have a right to remain silent? Nobody requires you to testify against yourself, but you can in fact waive that right. Do you understand that?
Yes, sir.
Page 3 of this document purports to have your signature in 2 different locations. Is that your signature in both spots?
Yes, sir.
Your second signature appears below a paragraph entitled Judicial Confessions and Stipulations. You understand that by signing that paragraph, it's just like you stood up here before the court, raised your hand and said, I did what the state's accused me of doing.
Yes.
Attached to the back of this document marked as State Exhibit A is a copy of the grand jury indictment. It purports to have your signature down at the bottom. Is that your signature?
Yes, sir.
And are you asking the court to accept as true and correct this grand jury indictment?
Yes, sir.
Do you feel like your client understands their rights, waivers, and admonishments?
Yes, sir.
The story, you've been charged with possession of a controlled substance, to wit methamphetamine from 1 to 4 grams. This is a third-degree felony with a range of punishment of 2 to 10 years incarceration and up to a $10,000 fine. Do you understand this charge and this range of punishment?
Yes, sir.
And how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
Are you pleading guilty because you are guilty and for no other reason?
Yes.
And are you a citizen of the United States?
Yes.
Do you feel like your client's competent and capable of assisting you in preparation for trial?
Yes, sir, I do.
Is there a plea agreement?
Yes, Your Honor. 5 years deferred adjudication, a $1,500 fine, drug and alcohol treatment approved by the probation department, complete the life skills program, and $180 of restitution to the crime line.
Is that your understanding of the plea agreement, Ms. Black?
Yes, sir.
Ms. Story, is that your understanding of the plea agreement?
Yes, sir.
Let's talk about deferred adjudication briefly. Do you understand deferred adjudication is like a two-sided coin? If you successfully complete all the terms and conditions of probation, not only do you not have a final conviction, but you may be entitled to file a motion for non-disclosure.
Yes.
Okay, do you understand the flip side of the coin? If you violate your terms and conditions of probation, you're subject to the full range of punishment on this offense.
Yes.
In addition to that, do you understand that a plea agreement is an agreement between you and the state? It's not binding on the court, but if the court did not accept your plea agreement, you would have the opportunity to withdraw your plea of guilty, enter a plea of not guilty, and proceed to trial.
Yes, sir.
And are you asking the court to follow the plea agreement?
Yes.
Court will find evidence beyond reasonable doubt to enter a finding of guilt. Pursuant to your plea agreement, will defer any such finding of guilt for a period of 5 years. You have a fine in the amount of $1,500. You must successfully complete a drug and alcohol treatment program if ordered to do so by probation. You must successfully complete the life skills program. You have restitution in the amount of $180, court cost in the amount of $290, and reimbursement fees in the amount of $1,652.50. Do you have any questions on the judgment?
No, sir.
Once you get released, can you work out a payment plan to pay back your cost?
Yes.
Attached to the back of the judgment is the order granting community supervision. Did you have a chance to go through this order with your attorney?
Yes, sir.
Did you understand this order?
Yes, sir.
You understand this order contains all your terms and conditions of probation.
Yes, sir.
You understand your terms and conditions of probation include a $60 per month probation fee,
Okay.
a
Yes.
one-time $50 Crime Stoppers fee that's due within 6 months.
Okay.
You understand you're subject to random urinalysis and drug tests at your own expense.
Yes, sir.
You understand you're agreeing to a search of your person, your place, your residence, your vehicle, or any electronics to ensure conformance with the terms and conditions of probation.
Yes, sir.
Do you understand you must successfully complete the life skills program?
Yes.
And do you understand you must successfully complete a drug and alcohol treatment program if ordered to do so?
Yes.
Where do you work?
I work at a restaurant in Bernie. Richter Tavern.
Okay. As a term and condition of probation, you're going to complete 125 hours of community service. Work with the probation department so they can work around your job. Do you have any questions at all on your terms and conditions of probation?
No, sir.
Good luck to you, Ms. Story. Thank you.
Have a good day.
Thank you. We know where Saldana is.
Is he waiting to be let in?
No, there's nobody waiting to be let in. You want to try calling him? Because they went to a lot of trouble to get us the paperwork. Hang on while we try to find your attorney. You're muted, so.
Sorry, Your Honor, I believe he thinks we have court at 1:30.
Why in the world he would think that, I don't know.
I don't know. I told him yesterday that it was at 8 this morning, so
I could try calling him.
I'm sorry about that, Your Honor.
No, it's no reflection on you.
He did go over my paperwork though, so.
We're trying to call him right now.
Yes, sir. Maybe he hasn't sent me.
I think it's October 8th. But we'll check. Well, actually, we do have September 29th. Yeah.
Yeah, but that's already a nightmare.
Yeah.
So it's October 4th.
8th, October 8th, right? Is that?
October 4th is the trial.
Oh. We tried that.
Okay. All right, we can't get a hold of your attorney. So that leaves us in the position where we're going to have to reset you for October 4th.
Can I waive my right to have him with me?
No, ma'am.
Okay.
Yeah, I'm not allowed to do that. So
Do you have his new phone number or no?
I can't answer that. I
Okay,
assume the DA has a current phone number.
okay, Your Honor.
So sorry about that, but we'll see you back on October 4th.
All right, thank you.
Thank you. David, do you have anything else pending?
No, sir. May I be excused?
You may. Have a great weekend.
Thank you,
Thank
sir.
you.
You too.